or even elsewhere. I think Dr. Murray is so reckless, based upon the law and the definition of criminal negligence that I read, and everything that I heard and saw in this case, and Dr. Murray's subsequent conduct, that I believe he's a danger to the community. I've taken into account all of the factors. I've stated my reasons, and those reasons, the nature and character of the offense, distinguish this charge of involuntary manslaughter in this case, and this conviction of involuntary in this case, from other cases involving involuntary manslaughter. And there's a fundamental aspect of the criminal justice system which is involved here, and that is the fundamental aspect of punishment. It should be made very clear that experimental medicine is not going to be tolerated. And Mr. Jackson was an experiment. The fact that he participated in it does not excuse or lessen the blame of Dr. Murray, who simply could have walked away and said no, as countless others did. Dr. Murray was intrigued by the prospect, and he engaged in this money for medicine madness that is simply not going to be tolerated by me. So as to sentencing in this case, the request for probation is denied. The court imposes the high term of 4 years imprisonment in this case. Pursuant to the Realignment Act of 2011 and the provisions of Penal Code Section 1170, Subdivision H, that 4-year sentence is to be served in the Los Angeles County Jail under the care, supervision, and direction of the Los Angeles County Sheriff. Dr. Murray is to pay an $800 restitution fine pursuant to the provisions of Penal Code Section 1202.4 and the statutory scheme therein, a $30 court security fee pursuant to Penal Code Section 1465.8, Subdivision A, Paragraph 1, and a $40 criminal conviction assessment pursuant to Government Code Section 70373. As a convicted felon, Dr. Murray is ordered to provide specimens and samples of blood, saliva, fingerprints, and palm prints for law enforcement investigative purposes and the state DNA data bank, and his willful refusal to provide any such specimens and samples is a separate crime. I am concerned about the restitution requests in this case. I sense that the people and the defense share those concerns. It's not often that courts are called upon to order restitution in the sum of $101,821,871.65 based upon a 3-line statement in an email and electronic mail. So the court is going to order Dr. Murray to pay appropriate restitution to the estate of Michael Jackson and to the children and other family of Michael Jackson, pursuant to the provisions of Penal Code Section 1202.4 and the case of People versus Lunsford, Lunsford, at 67 Calap 4th 901, in the amount and manner as determined by this court at a later restitution hearing, where the court can be provided by the people through Mr. Weitzman and through anybody else with more detailed information. Now, Mr. Walgren, as you know, Mr. Weitzman indicated that the above information is a combination of monies actually spent. Well, I'd like to see it. And, quote, some very sophisticated projections on the anticipated revenue stream from a concert that had been sold out before Mr. Jackson's death, end quote. I believe we've discussed during various motions in this case issues involving detailed financial records. Certainly the defense and the people have been interested in those types of records for the length of this litigation. But before this court can order and will order any such restitution, I need much more detailed information. And that may involve strategic choices on the part of the Jackson family and on the part of the estate, whether and under what circumstances those figures are to be released. But I'm not going to order restitution at this juncture based upon those conclusory statements. If and when the court makes a determination, the court can order that restitution be paid through the State Office of Revenue Reimbursement. I'm happy to set this case at a later point in time for a determination of more detailed restitution amounts. How many days in custody has Dr. Murray served, Mr. Gorgian? You're checking? Because I want to provide appropriate credits.
23 days actual.
Dr. Murray is entitled to 23 days of actual custody credits plus good time, work time credits of that exact same number, 23 days. So toward the 4-year sentence in this case, Dr. Murray received total credits of 46 days in custody. I invite counsel to suggest another date when this matter can be calendared for a determination of appropriate restitution, unless you want to simply defer it and notify me in the future as to a date. That's up to you.
Due to the complexity of it and the number of people I'll need to speak with, Your Honor, maybe it's wiser to simply defer it, and then we'll notify the court after I speak with defense counsel and the estate representatives as well as the family.
All right. Please be aware of 120 days. I'd like to address this within that 120-day time period. Let me ask you, before I advise Dr. Murray of his appellate rights, are there any additional questions, comments, suggestions, et cetera, on behalf of the people, Mr. Waldron?
No, only falling back to the restitution issue, if the court thinks it's better to maybe just set a date with the understanding that we'll be working toward that goal, maybe sometime in mid-January or...
I'm fine with that too. Mr. Murray, I don't know the defense position.
We're opposed to setting a date in January. We'd like to get this resolved quickly.
Well, do you want to stipulate to restitution of $101 million, $821,871.65?
Are you giving me exactly two options, January or $100 million?
No.
So I guess I'll...
No, it's important.
I'm next week, 2 weeks from now, something like that.
Well, I'm not so sure that's all that realistic. I always can set it on a date and vacate the date, but I think putting it over for a week or two is not going to accomplish much in view of what I would think would be a lot of financial consideration here. You know, I don't see that time frame as being unreasonable if there are facts and figures which have to be gathered.
Do we need to drag Dr. Murray in from jail for that?
One need not drag in anybody. Dr. Murray can waive his appearance.
I appreciate that.
You can speak to Dr. Murray about that. You know, I'm certainly sensitive to that too. I don't want to drag anybody in here unnecessarily. Counselor conferring with Dr. Murray.
Dr. Murray will waive his personal
Dr.
appearance.
Murray, you have a right to be present during any proceedings in which I make a determination of whether I'm going to order any restitution in this case, and if so, the amount. Do you understand that right, sir?
Yes.
Do you give up that right and agree that your interests can be represented by those of counsel?
Yes.
Counsel join in the waiver, Mr. Chernow?
Yes, sir.
There's an express and explicit, knowing and intelligent, free and voluntary waiver by Dr. Murray of his right to be personally present. So what date would you like to pick in January?